Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. You know, if you've taken any economics class, you will know that it is all about supply and demand. When it comes to those who want to achieve civilian disarmament, they oftentimes think that they're going to affect the demand, but every time they talk about taking more guns from us, we all run out and buy more. We have seen record sale after record sale after record sale. So their game plan to do away with the demand, it's not working real well. But I'm telling you, I've had an opportunity to read a new case. We're going to talk about that case today because they have come up with a fantastic plan to do away with the supply. And folks, they are executing that plan right underneath all of our noses right now. The goal is absolute civilian disarmament, and they have come up with a way through the termination of the supply chain to do exactly that. So today, let's get you all educated about how they are really going to disarm all of us. Okay, so the case we're talking about today is a case called Morehouse Enterprises versus ATF. It's a case that's brought by Gun Owners of America. This is a lawsuit by a Type 1, Type 7 FFL to stop ATF's new zero tolerance policy, which, as we know, is running FFLs out of business day and night, left and right, all around the country. Now, I do want to talk to you about the journey about how I got to this video real quick, because when I got the case and I started looking at the pleadings, I was like, hey, this is going to be really cool. We'll talk about this entire lawsuit. But as I began to read the pleadings, I got so engrossed with what ATF has been done and what you need to be aware about what ATF is doing here, because the all-out war that they are committing on the FFL industry it's literally Banana Republic, third world nation stuff that's going on here. You really probably will not believe it. Now, understand, these are not going to be my allegations. These are the allegations that are coming out of the pleadings from the Gun Owners of America, but I can assure you, and we'll put links for all of it down below, they got all the exhibits to back this up. Now, on a side note, Morehouse Enterprises, a Type 1, Type 7 FFL, did join in a lawsuit against the ATF to overturn their rule on unfinished frames and receivers. After doing so, then they were suddenly served with an inspection order. The ATF came in, inspected everything, thousands and thousands and thousands of transactions, not a single allegation of transferring a firearm to any prohibited person. There were 5 little clerical errors, which of course now has resulted in, ATF moving to revoke the FFL. As plaintiff's counsel put it to start the complaint, just to give you kind of a flavor of where we're going, plaintiffs bring this action seeking a preliminary injunction to preserve the status quo, followed by a declaratory judgment and permanent injunctive relief, restraining defendants from further implementing or otherwise enforcing a Department of Justice zero tolerance policy that was first promulgated in 2022 for partisan purposes and since then has been wielded as a political weapon by the Bureau of Alcohol, Tobacco, Firearms, and Explosives to revoke federal firearm licenses of numerous gun dealers across the nation. As grounds, therefore, plaintiffs allege the following. And this all has to do with the Biden administration coming in. They had an absolute all-out war on everybody's Second Amendment rights. And one of the things they were going to do is go after all of these rogue gun dealers. They did so, though, by amending some of the rules. We'll get to that in a moment. But when President Biden was first out puffing his chest about how he was going after many of these rogue gun dealers, there were 5 dirty sins that he announced that if you do any one of these, you will be revoked. They were: 1, transferring a firearm to a prohibited person; 2, failing to run a required background check; 3, falsifying records, such as a firearms transaction form; 4, failing to respond to an ATF tracing request; or 5, refusing to permit ATF to conduct an inspection in violation of the law. Now, I know some of you will never agree with anything that ATF does. I respect your opinion. I think many of us also could agree that these types of violations are the types of violations which would probably warrant rather severe sanctions. Is that what's happening here? No. You see, what the Biden administration has done is they've rewritten all of the rules so that essentially ATF can determine everything, and I do mean everything, simple little clerical errors, to be willful violations deserving of license revocation. You see, what we need to talk about is ATF's administrative action policy, what's called the AAP. Now, in 2019, it kind of looked like this. But by 2022, it looked like this. Now, the two things that it really did is, number one, it significantly, and I do mean it significantly, increased the types of penalties that would be handed out for significant violations. It also removed discretion from the field agents, which is important, and it redefined willful. You'll understand in a moment why all three of those are important. In removing basically any discretion that the ATF may have, the results, as plaintiffs put it, were, it is no wonder then that last year ATF found extraordinary circumstances and provided alternate resolutions in only 4.7% of revocation cases. But you see, there also, and many of us know this, but now it can be internally corroborated, that there's been a significant cultural change at ATF. Beyond the toxic culture that they already had, they're literally playing a game now of how many licenses can we get revoked. As plaintiffs' counsel put it, expressing their concern in a letter to ATF Director Restaino, 25 members of the House of Representatives noted that under ATF's new zero-tolerance policy, local ATF field agents have shared they feel pressured to take actions against individual businesses that they do not feel are appropriate or in the interest of public safety. That some have even reported that ATF field divisions are being pitted against each other and are being forced to compete on the number of licenses revoked, and that ATF directors of industry operations who oversees revocation proceedings are being told to press forward with this escalating quota system or face personal repercussion. Now, I also said that they had removed all of the discretion, because as this ultimately comes down to any violation of an ATF, the license can be revoked if the ATF determines that it is a willful violation. Now, the IOIs, the ATF agents who are actually inspecting and conducting these inspections, they would have some discretion in the past to weigh in on whether or not they believed it to be willful. That discretion has not only been taken away from the field agents, it's not only been taken away from their supervisors, it's not only been taken away from the regional directors, it's actually been taken away from the ATF altogether. It's actually been taken away from human beings altogether. Yes, that's right. The agents who are conducting these inspections enter a bunch of data into a software system, ironically called Spartan. Spartan then spits out the sanction. I'm not making this up. As plaintiffs' counsel put it, thus, when asked in a recent revocation hearing whether in preparing the report of violations, is the issue of willfulness ever a factor, the ATF inspector responded, I input data and Spartan does the figuring. When asked a clarifying question, in this report of violation that you did, are you commenting on the question of whether or not the violation was done willfully? The ATF inspector answered, no, sir. That's not my job. But wait, it gets even worse. Later, when asked, you don't even get into the issue of whether or not the error was intentional or reckless or just human error. The ATF inspector answered no, unless the FFL directly refused to comply with record-keeping requirements. When pressed again why ATF had charged a single disposition out of roughly 7,000 transactions, the ATF inspector responded, Spartan does the configuring. But this crazy allegation has actually been corroborated by the Department of Justice. According to the pleadings, the Department of Justice, Office of Inspector General, confirms this state of affairs, stating that when an IOI enters inspection results into Spartan, the system prompts the IOI with a recommendation consistent with administrative action policy. Upon information or belief under the current AAP, the finding of willfulness necessary to initiate revocation of an FFL is made not by any human being, but rather an ATF computer algorithm. In other words, willfulness is no longer found by an individual based on facts, circumstances, and the exercise of human judgment. Rather, it is presumed by a computer software based on nothing more than the category of record-keeping violations that are discovered and fed into the computer system. But listen, if you think that's bad, no, it gets way worse than that, because not only has the ATF changed all the rules, they're going back and taking a look at old investigations which closed out with no adverse findings, or at least not a license revocation, and they are reopening them, and they are now reanalyzing them through their new and improved rules. As plaintiffs' counsel put it, adding insult to injury, not only has ATF implemented the 2022 AAP with respect to new inspections and revocations of FFLs, but also ATF has reopened old cases revoking the licenses of gun stores to whom ATF previously issued a warning letter or held a warning conference and who subsequently have rectified their mistakes. So, what is the byproduct of this crazy, almost third world banana republic type regime going around and enforcing firearms regulations? Well, you guessed it, and plaintiff's counsel put it this way. Indeed, ATF revoked 92 licenses in 2022, the most since 2008, which more than triples the number of licenses revoked in 2021, even though a similar number of dealers were inspected both years. And for those that they cannot absolutely just shut down by revoking their license, well, they're driving them out of the business through coercion anyways, as plaintiff's counsel put it. In addition to revocations, ATF has coerced and intimidated an ever-increasing number of FFLs into voluntarily ceasing operations. In fact, the number of FFLs who discontinued businesses following a compliance inspection increased from 96 in 2020 to 789 in 2021, the year that zero tolerance was adopted, to 1,037 in 2022, an overall increase of more than 1,000%. Now, I also mentioned that in order for an FFL to truly get their ticket punched, there needs to be a finding that the violation was willful. Now, the old rules, the 2019 rules, really actually were based on, objective criteria that would really probably demonstrate that, in fact, the actions were willful. Well, of course, the ATF didn't like that because they needed to expand willfulness to include, just about any type of clerical error, and they have done so. And how they've done that is by actually using the good reputation and expertise of a lot of reputable FFLs against them. Let me explain how. In 2019, the ATF could establish willfulness one of three ways. One, a history of similar violations brought to the FFL's attention by the ATF. Two, prior acknowledgement of federal firearms regulations in prior inspection reports. And three, statements or admissions by the FFL. But of course, that definition was just not broad enough to encapsulate all the activity that ATF wanted to encapsulate in it. So in 2022, they added three more factors, and you're going to love this. They're going to actually use the good reputation and a good performance record of past FFLs against them. The new criteria, in addition to the previous three, now include 4. Publications and information provided to the FFL which explains the FFL's legal responsibilities. 5. A history of past compliances by the FFL with the same regulations. And 6. By demonstrating that the FFL has substantial experience as an FFL. That's right. The more reputable you are, the longer you've been around with no violations, the more the ATF could use that against you to demonstrate that it was a willful violation. And let us remember that when you get your FFL, you have to sign for all the federal regulations, and therefore ATF is using that signature of the FFL saying, listen, we gave you all the regulations, you signed that you got them, now you violated one of them, that is willful under this new test. And so, a long history of always coloring inside the lines as an FFL is actually going to hurt you. As plaintiff's counsel put it, nevertheless, based on factors 5 and 6, ATF believes that a lengthy history of an FFL following the rules should be used to prove that the FFL willfully failed to follow the rules when a mistake or oversight inevitably occurs. In other words, the longer and more faithfully an FFL has followed the rules, the more severely it can be punished for an inevitable inadvertent slip-up, leading to the perverse incentive structure where a history of good behavior is grounds for more serious punishment. So the determination of willfulness is now being based upon a computer algorithm, not a human being, using an expanded definition in which the more reputable the FFL has been in the past, the more easily they can be punished. That's the actual system. Now, in addition to that, there is this sick and horrible thought process meandering its way throughout the entire ATF where this whole, I'm sorry, it was a clerical error, it was a mistake, is irrelevant. Don't believe me? This is how plaintiff's counsel quoted a member of ATF. ATF Director of Industry Operations, Hans Hummel, of the St. Paul Field Office, recently opined in a 2022 revocation letter that, quote, arguing that errors were the result of human mistakes or harmless misunderstandings is irrelevant to the standard of willfulness. But you see, Director Hummel, that is exactly the opposite of what 18 USC Section 922, Section G3 states. And so what the ATF is doing here by rewriting the rules is absolutely violating clear and concise provisions of the Firearms Owners Protection Act of 1986. They are holding FFLs to a standard that accountants are not even being held to, okay? A simple clerical error is now being determined, regardless of the history, in fact, the better the history, the worse it is, to be a willful violation and thus warning a revocation. And now we are seeing not only a tremendous amount of revocations, but we're seeing many in the industry saying, you know what, I can't deal with it anymore, I'm out. And we have now seen over 1,000 FFLs nationwide shut down. But could the ATF actually hold themselves to their own standards? Let us not forget what the Office of Inspector General has said about ATF record keeping and the millions of firearms that they have never been able to account for throughout their course of existence. Or as plaintiffs' counsel put it, in sum, ATF's own horrible history of unaccountable firearm record keeping shows that the agency would never itself be able to achieve anywhere close to the standard of perfection that the ATF, through its unrealistic AAP, demands from the nation's FFLs. So, as you can see, there is a concerted effort underway by your federal government, now that the ATF has been let off the leash, to absolutely run every single FFL out of business. And when the rules didn't permit the ATF to do that, well, they just rewrote the rules. Thank God that the Gun Owners of America has jumped in. Thank God that this lawsuit's going on. We're going to have to very carefully watch this, folks, because we in the Second Amendment community are all dependent upon the FFL industry to ensure our otherwise inalienable rights. The case, once again, is Morehouse Enterprises versus ATF. We'll put links for that down below so you can follow it. And if there are any other updates, we will be sure to let you know. We got other videos coming out about this case because we didn't even get into all the injunctive relief and other things that are still in this complaint to be covered. In the meantime, if you have any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now, but if you don't, that's okay. That information is down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.